Starting with case number 17CA011234, State of Ohio versus Walter James. Each party will have 15 minutes to present their arguments to the court. The appellant may reserve up to 5 minutes for rebuttal. If you're going to reserve rebuttal time, let me know and I'll keep track of that for you. The oral arguments are being recorded and posted on the court's YouTube channel. We use the front podium. So if you could stay at the podium and keep your voice up so we can get a good recording, that would be appreciated. We've read the briefs and are ready to proceed when counsel is.
Good morning to the panel. I'm Attorney Matthew Bobrowski here on behalf of Attorney Michael Duff, who retained as appellant counsel in this case. We made two assignments of error, one for manifest weight and one for sufficiency. Basically, I will deal with the manifest weight argument first, as it is the more lengthy portion of our brief and was given substantial time. Without belaboring the point, the court obviously knows the manifest weight standard, and essentially when we reviewed the testimony taken at trial, reviewed it, we looked at it for what was actually adduced, the evidence actually adduced. And primarily there were the two witnesses, the alleged victim and Mr. James, the appellant's ex-wife. They essentially, when they talked, their testimony was given, the allegations were very substantial. I mean, there were substantial allegations of abuse that took place over a period of a number of years from the time the young girl grew well into her 20s. The first thing we acknowledged and we looked at was the fact that a lot of this became...
Counsel, could I interrupt you for a second? We prefer if you don't use the victims' names.
Okay,
Especially since this is a victim that the allegations would, especially when she was...
I apologize.
No, that's okay. I'm just saying.
I will. AW initials fine. All right. AW. She came to. She did some therapy in her 20s, and at that time, her testimony was that her memories of the abuse, and she came to be able to talk about the abuse in a way that she was able to cope with. However, to that point, she had had a very loving and close relationship, by her own testimony, with Mr. James. Mr. James she sent letters that were brought to evidence at trial, where she said that she loved him more than all the jelly beans in the world. Now, obviously, the state, in its arguments, said that Ms. AW was able to distinguish between her father and her abuser, even though they were, in fact, the same person. But what we have is this lengthy period of time where you have, even after she left the house, she treated Mr. James as her father. She went to him she trusted him, she went to him. This does not seem to coincide with what the allegations were, that even after she left the house, that they continued to have a sexual relationship. I'm sorry,
We know what you mean.
I know what I mean, and I'm stumbling over it, and I'm not going to accomplish much by making it jumbled legal Latin. The conduct, our position is that the conduct did not fit what she alleged happened. Furthermore, she even alleged that...
Counsel, I was going to interrupt you just for a second. When did this alleged abuse start?
The alleged abuse began...
What age was she when it was supposedly started?
All right. I believe that they moved in together when she was 7, and
It's okay. The point of it is she's a very young girl.
Very young girl. I believe 9 to 10,
So-
there was a distinction, I'm sorry.
No, the only point of that is, so you're saying this conduct doesn't really go along with somebody that's abusing you. Well, if that's all you've known all your life,
And that certainly is a consideration, and it certainly is what the state is going to argue. However, the issue is that she even testified that there was a financial consideration. That when she finally broke off contact with Mr. James, she didn't immediately pursue any kind of criminal charges, any kind of investigations, because she was hoping that Mr. James would essentially do right by her mother, Miss Houston, and her siblings.
that, you know what, that reminded me of when I was reading it, for domestic violence victims that don't report because they're afraid that they'll lose their home, they'll lose any kind of financial support they have, that they won't be able to live in the world, basically, so they put up with the abuse.
And that certainly is a consideration, and by no means are we minimizing that as part of the, what AW tested, her motivations. But what we're saying is, when taken in the totality, it calls into question what actually happened. Now, she did testify at length, and I'm not going to minimize, she testified at length, truthfully on direct examination in regard to the details of the alleged abuse, which did, in her testimony, include vaginal penetration, both digitally and penally. It happened, she testified it happened over a course of years. But when you take that testimony and you look at what Ms. Houston testified to, Ms. Houston testified that she and Mr. James put AW to bed until she was 11 or 12. She never noticed any anything that made her be concerned. And it wasn't until there was a previous allegation of abuse in 2003, AW apparently said something to a friend who was then reported I believe it was a Bible camp. Children's Services got involved. Ultimately, though, AW did recant, and Ms. Houston said that after that incident, the family was stronger. Now, but she did say that her relationship with AW, Ms. Houston's relationship with AW, was not as strong. And AW admits that she resented her mother for taking Mr. James back. Now, but what also should be noted is Ms. Houston did suffer a rather severe breakdown at that point, and essentially was bedridden, did not work. But she also testified that her family was stronger post the initial allegations in 2003, and that she herself never suspected anything. She thought that nothing had happened. However, when AW did go through therapy, she testified that she spoke to Ms. Houston. Ms. Houston also talked about this conversation where she told Ms. Houston what Mr. James had allegedly done. Now, at that point, Ms. Houston did not immediately confront Mr. James, but she went home, she thought about it over several days, and Mr. James, when she confronted him, he didn't deny anything, but she did use basically body language to assume that he had committed these acts. She kicked him out. However, what you have is, and our position is that when you look at the totality of Ms. Houston's testimony, over all those period of years, she never noticed it. Now, admittedly, she never noticed anything that gave her cause concern, even though you had this previous allegation in 2003. And there was a time that when she was incapacitated, she was bedridden, but there was a period after that where she'd gotten better. She got out of bed, she got her life back in order, and it's still at that point she never had cause for concern regarding Mr. James and AW. So what we have is, we have these two witnesses who gave evidence, and admittedly, Ms. Houston, the state made the point, and it is a point that people don't always see what's in front of them. You know, these acts that Mr. James was alleged to have done are the type that are not done in public, not in public, but in the full viewing of the family. And it's certainly, you can certainly make the argument that Mr. James was able to conceal what he was doing. But that is not what Ms. Houston testified. Ms. Houston testified that she didn't have those concerns. She thought her family was stronger, even with previous allegations.
Aren't you arguing, counsel, the credibility of these witnesses? And isn't
I do think that, yes, and it is the province of the jury, but in manifest way, and you get into sitting as the 13th juror. Now, obviously, the finder of fact is best equipped to determine credibility, but we are, and this is where it's a subtle distinction, and it's a distinction that I at times struggle with when I make these types of arguments, is that when you sit as the 13th juror, you have to listen to what was said at trial, you have to look at what the evidence that was put forward, and you have to try to parse credibility. So and it becomes weighing the various portions of their evidence without impermissibly going into the province of the jury and acting and judging credibility. I know it's a difficult and at times almost impossible thing to do without, and I will say that if it came down to that this becomes a credibility argument, then obviously the manifest weight argument would have to fail. However, I think that this is not going strictly to credibility, it's going to what was actually said, the evidence that was presented, and taking it in the totality of the context.
Let me interrupt because you have 3 minutes and 50 seconds total time left. Did you want to reserve?
I'm not going to reserve it.
You're not going to, okay, you can continue then.
All right. Essentially, to briefly state our sufficiency argument, I will just quickly go through that. It was a very general one, and one that I understand has some issues, but our point of view is this, and we'll be very brief on sufficiency. There was a great deal of testimony from AW with regard to when the alleged abuse occurred. However, there were, even she admitted to being, there were some gaps, particularly after he returned to the home in 2003 to 2004. And it's our point of view that the elements of the charges, with regard to some of the allegations, were not sufficiently proved as to when things occurred. Now, I understand completely that there's a great deal of case law out there that says you don't have to have specifics, particularly in these types of cases where you can prove a period more so than a specific year, you don't have to prove specific dates. We were talking in a more general sense, not so much as to the totality of the period, but as to year by year, where certain things, there was certain gaps even in the testimony, though you could also argue that there's a lack of specificity as to what was those gaps. But we think that particularly for 2003, 2004, 2005, there are issues as to whether the state did prove all the elements of the charges. However, I will acknowledge that, yes, you can find that the testimony did cover the periods, though not with the honesty year by year. In summation, essentially what we're looking at here is we think that the state did not meet its burden of proof at trial, though that the jury lost its way because of with regard to the evidence actually presented.
questions, Judge Carr, Judge Schetzel? All right, thank you for your presentation. Counsel, you'll have 15 minutes, of course.
Thank you, Judge. Good morning, Your Honors. Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office. For the record here, first of all, seems sort of logical to proceed first with the sufficiency portion of the argument and whether essential elements of the crime were proven by the state at trial here. And what the state's argument is, really comes down to is a reading of Mr. James's brief doesn't contain any challenge of any element of any charge. By his own admission, while he's here before you today, Mr. James, whose counsel said he presented you with a very general argument, and that's just not proper in the appellate realm here. Mr. James needs to present to you some kind of argument that says this element wasn't met. He does not say that sexual conduct was not offered by the state. It clearly was. He doesn't say that force wasn't offered by the state. It clearly was, especially when you consider the fact that the victim of the force was between the ages of 12 and 13 under count 2. And you have a step-parent, a stepfather in this case, which really lessens the hurdle of force that needs to be met under the case law when you're dealing with a relationship between a step-parent and a child, of course, and you're well familiar with that. The victim's age in count 1, that's not contested. The mental state in count 1 under rape is really a strict liability statute. Count 2 requires purposely compelling her to submit by force. And then you have the multiple counts of sexual battery. There's no element put before you in that brief that says specifically what element the state did not meet. And the state will also submit to you that by placing that sufficiency argument second in its brief, or his brief, Mr. James brought into, he incorporated arguments made in the first part. Well, that first part's a manifest weight argument. That brings into issue things like evidentiary conflicts and credibility, which just aren't relevant or proper to make in a sufficiency of the evidence argument. And the sufficiency argument, of course, goes to essential elements. The date here under the first 6 counts changes by year, essentially. 2001, 2002, 2003, 2004, 2005, 2006. So you're looking at time periods really of January 1st, 2001 through 6 to December 31st of 2001, 2006. Those are not elements of the offense, and it's not an appropriate or proper argument to make under the sufficiency of the evidence assignment of error. The only time that the year or time period is relevant, Your Honors, is under count 2 which alleges that the victim, AW, was under the age of 13. And I submit there's no question that the evidence supported that fact. And secondly, the argument isn't, this sufficiency argument, specifically in the brief, relates to 2004, 2005, and 2006. It doesn't even relate, there's no argument even made regarding that 2002 year. It all relates, they say, after 2003, after that after the criminal and child services investigations had culminated, so they were finished, and then there's an argument from Mr. James about the years 2004, 5, and 6, in which age is not an element. Even looking at the sufficiency of the evidence, Mr. James says there's some gaps with regard to the evidence. In the years 2004, 5, and 6, what AW testified at trial was there was a period of time in 2003 while that criminal and child service investigation was ongoing. It then ended. And during that period of time, and for a few months, she says, after those investigations ended and Mr. James was allowed to return to the home, so he'd been gone, so there was no sexual abuse going on while those investigations were ongoing. And then for a few months, she said in the transcript, after he was allowed to return to the home, I believe that was in March of 2003, so a few months. And then the sexual abuse resumed in 2003. And she said it never stopped. With regard to the manifest weight arguments, the state points out, as this court noted, this challenge raises nothing more than credibility issues, and the jury got to consider the credibility of the state's two witnesses, to evaluate the testimony, and to believe the version of events that the state put forward, and to then find Mr. James guilty. It was described as a lengthy discussion in the brief, but as the state points out, this manifest weight argument that was offered to you was nothing more than pages upon pages of facts setting forth the testimony, and the argument came down to, on 7 convictions, 2 counts of rape, 4 counts of sexual battery, with significant, disturbing, compelling testimony from the victim AW. You got 1 paragraph and 10 sentences regarding the manifest weight. Stuff like the therapy. The therapy is not what brought these allegations to light. AW testified that maybe it made some things more clear, but it certainly gave her a way to deal with the trauma she'd been through. But it was not the primary vehicle for the abuse coming to light here. The financial motivation is, as the court has noted, a thread that runs through multiple types of criminal cases that we see, as Judge Carr pointed out, domestic violence cases. And here, AW was in her late 20s. She had siblings. She had a mother who needed financial support. Mr. James was providing that financial support, and she was hoping he would continue to do so if perhaps she withheld going forward with divulging the abuse to police, which I presume she knew would almost certainly lead to some kind of criminal charges. And when Mr. James didn't do that, she decided that the appropriate thing to do in her life was to divulge, to go to the police and let them know what had happened involving Mr. James. It's quite the opposite. The financial motivations, there was never any evidence that she had sought money from Mr. James. She simply sought to have him provide the support that he was already providing to her mother and to her two, I guess, half siblings, her 2 siblings. The letters, it was absolutely compelling and frankly disturbing to read that transcript, and the way that AW was able to compartmentalize, to differentiate between her father and her abuser. That's not something that could just be made up in order to bring forward these allegations against Mr. James. There was that one part where she told the jury he was saying he was going to marry her if her mom died. When when she was as young as 13 to 17. Again, not something that could just be made up on the spot. That lends credibility to her testimony and why the jury believed what she had to say. Her mother testified to her relationship with Mr. James being stronger after those criminal allegations and the child service investigation. A.W. testified that she hated and resented her mother. The family dynamic was not stronger, but she hated and resented her mother, which is why she relied on her father so much, and why she was making that distinction and why she stood by him in some way. That was the parent that was able to provide for her, whom she was able to rely on. And lastly, with regard to the body language, the body language, it's not like Mr. James didn't just stood there and his wife at the time just read his body language. What she was saying is that after 20 years of marriage with Mr. James and interactions with him, she was able to read what he said and how he said it and realize what had happened and what what her daughter had told her had credibility, had credence. The testimony was Mr. James didn't overtly admit anything, but he got as close to a confession as possible when he didn't even protest. He told, according to the testimony, he told his wife, "I know you spoke with your daughter, and I'm not going to argue with what she said." Knowing that she had accused him of a decade and a half of sexual abuse, he didn't protest, he didn't argue, and his wife responded by throwing him out of the house and divorcing him, and that's pretty strong evidence there too for the jury to believe, taken into consideration, believed and arrived at the verdict they did. So at this point, without any questions, the state has to affirm the convictions.
Okay, thank you very much for your argument as well. Court will take a matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to counsel on the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website.